how the courts are organized. You've spent a lot of time learning yourself how it works. So can you tell us more about that?
Okay, so the way it works in our judicial system, first you need to start at the lower level, which is the tribunals and the commissions and stuff like that. And then once you get the decision from there, then you can do what they call a judicial review in federal court. And depending on what the answer is, you can bring that to the Federal Court of Appeal. And then after that is the Supreme Court of Canada. And so when I first started, I brought my case of genetic characteristics perceived disability to the Canadian Human Rights Commission. They essentially used the wrong definition of genetic test, which I'll get into that a little bit after to expand on that. But what happened is that because they used the wrong interpretation, they said there's no discrimination here, there's no there, essentially. And because of that, your case is frivolous and we're not going to look at it. And so and after that, it goes to the next. Actually, if you go to the Genetic Non-Discrimination Act, that's probably the second or third or fourth link. The Canley one.
Canley. Okay, so maybe that's
no, that's the Labor Code. There's
okay,
another one.
the second.
There's a Human Rights Act, and then the next one is that's okay. So this one over here. So if you see over here in the Genetic Non-Discrimination Act, if you scroll down, it's genetic test definition under Section 2, Article 2, and yes, Section 2. It says just go up a little bit. Yes. So definition, the following definition applies in this act. So it says in this act. Okay, so that's a Genetic Non-Discrimination Act. Disclosed includes to authorize disclosure. A genetic test means a test that analyzes DNA, RNA, or chromosome for the purposes of such as the prediction of disease or vertical transmission risks or monitoring, diagnosis, or prognosis. A genetic test. So in the case law from that, if you go to the other screen, the tab right next to it. No, on the other side on the right. The reference.
Okay,
so the act came into force in 2017, and now there's been a decision at the Canadian Supreme Court of Canada in 2020 regarding Section 1 to 7 of the Genetic Non-Discrimination Act. And if you look at paragraph, I think it's 124. If you look at paragraph 124, it will say that the genetic test in the definition of the genetic of the sorry the definition of the genetic test within the Genetic Non-Discrimination Act is a narrow health definition only. So, and then in the Canadian Human Rights Commission, that's what they said. They basically said, well, it's only for a test that analyzes DNA, RNA, example, to see if you're going to have Parkinson or if you're going to have cancer. And that's the genetic test they're talking about. So if you go to paragraph 124 or 126, I think, around there.
Yeah.
So it's much further down, much further down. So 124.
Thank you.
Okay. No, it's probably 125 or 126. Maybe 126. Let's just look at 126.
Okay.
Okay, let's see. Okay, so I think it's this one. So the Parliament record bolsters my conclusion regarding the purpose of the provision in question on my reading of the debates and the testimony heard by the Senate and the House of Commons committees tasked with reviewing the Bill S-201. So that was the bill for the Genetic Non-Discrimination Act, an act that prohibit and prevent the genetic discrimination. Furthermore, okay, the focus was clearly directed at the devastating health consequences that were resulting from people foregoing genetic testing out of fear that the personal health information revealed by such testing could be used against them, including in discriminatory ways. By enacting Section 1 to 7, the Act of Parliament sought to prohibit conduct that was causing individuals who wish to undergo genetic testing to instead forego such testing to the detriment of their health. So if I think maybe it's 119, it actually says that it specifically says the keyword that it's for. One second, I'll just look on my end as well. If you look at this, Okay, yes. Okay, so it's in this one. Yes. So if you go in the middle of the paragraph, it says go down, down, down. It says the definition of genetic test is accordingly restricted to tests that are taken for health-related purpose, such as predicting, preventing, and diagnosis hereditary disease and guiding treatment options for a wide variety of disease and condition. This demonstrates that Parliament was squarely focused on protecting health. So, but that's for the definition of genetic tests within section 1 to 7 of the Genetic Non-Discrimination Act. Now, if you go back to the Genetic Non-Discrimination Act tab, I think it's the other one. Oh yeah, that one.
Yeah,
So
yeah.
if you go down, if you look at section 1 to 7, if you scroll down a little bit more, okay, all the way up to there, that's the definition of genetic test within that. Now, if you look at section 9, Amendment 9, and Amendment so Amendment 9 and 10 of the Canadian Human Rights Act, these are the amendments to the Canadian Human Rights Act that have a different definition. So if you go to the Canadian Human Rights Act, if you look at section 2, if you see it says ground of discrimination in there, you'll see right before disability and the before last line.
Yeah, I
It says
see.
genetic characteristics. Okay, so that
Yeah.
been added there. But that amendment to the Canadian Human Rights Act was brought in by the Genetic Non-Discrimination Act that amended that. Okay, but if you look,
Yeah.
as you scroll down to section 3.2, so 3.2, actually no, 3.3. So it says where the grounds of discrimination is refusal to request to undergo a genetic test or to disclose or authorize the disclosure of the results of a genetic test, the discrimination shall be deemed to be on the ground of genetic characteristics. Now, here they don't provide a definition of genetic test, unlike the Genetic Non-Discrimination Act is specifically for narrow health-related tests. In here, it's broad, and you can see that if you go back to under the decision of the Supreme Court. Okay, go that one, and then you go to paragraph 191. Yes, so 100. Yes, in this one, go paragraph 191. So all the way down.
191, yeah. Mm-hmm. Oh, it's a long document. I can see. Yeah, okay.
Yes. So
191.
191 right there. So it says the amendments to the Canadian Human Rights Act also encompasses a broader range of genetic information than section 1 to 7. So here you see the contrast between the two legislation. The Genetic Non-Discrimination Act uses one definition, but it also modifies the Canadian Human Rights Act under section 9 and 10, and the modification encompasses a broader range. Now it says, first, since no definition is provided for genetic characteristics, the protection is not limited to a narrow health-based definition of genetic test. So my argument is that if you request for an accommodation, they said, well, then you have to test. You have to take a PCR test to disclose your status, essentially. And a test, a genetic test, a PCR test is a genetic test according to the broad definition of paragraph 191 over here. However, this conversation was had in what they call obiter dicta, because it's not relevant to the case at hand. And I'll get to that in 1 minute. But first, let me finish this one. Second, by protecting genetic characteristics rather than information disclosed by genetic test, the amendment to the CHRA, which is the Canadian Human Rights Act, include genetic information obtained through other means. So my argument on that is that by asking for my vaccination status, they're indirectly asking my vaccination status. They're indirectly trying to obtain my genetic information indirectly by other means. By asking whether I'm vaccinated or not, it's going to disclose to them what is my genetic makeup, whether I can make those antibodies or not. And for me, that falls under the privacy and also under the Canadian Human Rights Act, where I have the right not to disclose that information. Okay, so that's where I'm at in this argument. So it says the deeming provision supports this interpretation. The Canadian Human Rights Act specifically ensures that one cannot be forced to undergo a genetic test and that the results of a genetic test cannot be forcibly disclosed, which does not preclude the fact that a broader range of genetic information is protected. The broad purview of the Canadian Human Rights Act goes to show, in my respectful view, that section 1 to 7 also cannot be characterized in pith and substance of protecting individuals' control over private information. So in here, they're basically saying under section 1 to 7, you do not have control over the private information because medical people have access to that information. Whereas under the Canadian Human Rights Act, you have control over your private information. Now, if you go back to paragraph 123, this is in the concurring opinion. It will basically say that the sections 8, 9, 10, 11 were not at issue within this decision. So the conversation they had is called obiter dicta conversation. There's other Supreme Court case law that says that obiter dicta, if it's integral to the main decision, should be considered as case law. Okay, so if you look at paragraph 123, if you scroll down a little bit, it basically says that. It says, the constitutionality of section 8 and to 10 of the Act, which amends the Canada Labor Code and the Canadian Human Rights Act, is not an issue. Nonetheless, the jurisprudence instruct that where the challenge concerns a particular provisions which forms part of a larger scheme, the matter of the provision must be considered in the context of the larger scheme, as its relationship to that scheme may be important consideration in determining its pith and substance. And so, and then it further says that here, in my view, considering section 1 to 7 of the Act, alongside of section 8 to 10 of the Act, reveal important distinctions that shed light on the precise purpose of the provisions at issue. So when I read that, it clearly shows that the Genetic Non-Discrimination Act is split up in two parts. There's 1 to 7, which means one thing, and then there's the amendments to the other, to the Canada Labor Code, and amendments to the Canadian Human Rights Act. So now if you go back to the court image process, court picture with all the different courts, yes. So when I brought my argument to federal court, okay, they basically repeated the same thing that the decision maker said, and that was all stemmed from the human rights officer. The human rights officer who looked at my file, they used the wrong interpretation. They used the definition of genetic test from the Genetic Non-Discrimination Act, as opposed to use the broad purview interpretation of the Canadian Human Rights Act. And I'm trying to bring that to the attention of the federal court back then, but again, it was my first time in court. And so my argument was not as well polished. So then I brought this up to the Federal Court of Appeal, but just to give a little bit more perspective, so the federal court, that was last year in 2023 on June, sorry, was it last year or the year before? Anyways, it was a while back. Anyways, I got my date at the Federal Court of Appeal. That was on October 10th. So on October 10th, I went to the Federal Court of Appeal, but just prior to that, on October 2nd, we were in the hospital with my wife. We lost our baby. We had a stillbirth at 20 weeks plus. And then so we were in the hospital. I was in the hospital trying to get all my documents. I had 3,000 pages of stuff, and my mind was very distracted. I tried to write something like of a draft when I was trying to prepare for my to go argue my case in front of the Federal Court of Appeal in front of 3 judges. And then I printed a draft, but then I had a computer virus the 2 days before, which I lost a lot of my files and documents. I was scrambling for that too. I was very sleep deprived. Anyways, long story short, when I was in federal court, I couldn't find my draft about the genetic characteristics. Like, I talked briefly about it, but I didn't fully dove into it. And anyways, so when I got the decision now at the Federal Court of Appeal, my decision won in part. So the perceived disability arguments that I was making, I won on that, that's why the line goes back to the federal, the tribunals, because they're sending it back to the commission for them to revise based on perceived disability, and I'll get to that in a minute. But now to bring back the genetic characteristics, that has not been addressed. They basically just said, well, we're not convinced about this one. We're like, they're not really wanting to look into it. And so that's why it brings me up to the circle right now where it says, I'm bringing this part of the decision to the Supreme Court of Canada, and that's the stage I'm at. But in order to get to the Supreme Court of Canada, you have to do what they call the leave request. And the leave is basically 3 judges that will look at all the cases that are submitted. There's approximately 800 cases that are submitted, and they only accept 10% of that. And that's basically 80 out of 800. And then so once it passed through that kind of a gatekeeper, I say in air quotes, then it can go to Supreme Court. Because, again, this would give an opportunity for the Supreme Court of Canada to clarify what the genetic test definition means under the Canadian Human Rights Act. And then because the Supreme Court decision of 2020 does not address that, it was not at issue. Well, now I'm making an issue out of it, and that's where that is on that front. And that brings us to essentially today, which right now we have to file this by January 7th. And then I looked into getting a law firm to partner up with me on that, just because at that stage there's so many different levels of technicalities, and it's very very precise in terms of wording and stuff like that. So I figured with my knowledge of what I got so far, I mean, I brought myself all the way up as a self-represented litigant all the way to the Federal Court of Appeal of Canada, and I won in part, which is a great feat in itself. But I feel for the extra mile, the law firm can help to basically get the argument over to the finish line, which is the Supreme Court. But in order to do that, we have to file a leave, and to hire the law firm, it's about $25,000, and that's where it brings up to the Give Send Go campaign that I created. I don't know if you have that link handy.
Yeah, I will include that link. It's included in the Substack, which I have published a couple of days ago, with your press release. So, can you tell us why your union is not supporting you? Like, why do you have to do it all yourself?
Well, the message that I received from a union originally was that there's no case law precedent on that, and they've also used the incorrect interpretation. So right now there's bad precedents set up, and people are using the wrong interpretation of the 2020 decision, and they're basically implementing the decision from the genetic test definition of the Genetic Non-Discrimination Act they're incorporating that into the the Canadian Human Rights Act, which is wrong based on this over here, based on the conversation that they've had. There's supposed to be a clear distinction and broader protections under the Canadian Human Rights Act. And this is why I want to bring that up. But back then, when I first asked my union, there's no case law. It's so new. This decision of the Supreme Court was in 2020, and the law came into effect of 2017. So in case law perspective, it's very, very new. And that's why, because there's no guidance, that's why they're just like, well, we're not going to go that route. But if you feel you should, like, if you feel that it should be addressed, contact the Human Rights Commission, essentially. And they basically used the same thing and basically said, no, this is frivolous. And that's why I want to bring that up to the Supreme Court.
Okay. Thank you for clarifying all that. So, indeed, you are trying to do something yourself to essentially to restore some of the losses you've taken in 2022 when you put on leave without pay. But I guess you realize probably that the likelihood is probably not high that even your case will be considered probably for Supreme Court.
Yes, it's 1 in 10% chance, essentially. It's it's a 10% chance of them to accept my case to the Supreme Court of Canada, and it's a long shot, but it has to be done. I have to try it, because the way it stands right now, it leaves a bad precedent behind, and the precedent was not even acknowledged. The thing is that other people can use the case that I was part of the Federal Court of Appeal and just say, oh, well, according to this decision, this is what it means, where it's wrong, because it was never really addressed. But because it was within that hearing, they can just put that, like the main keyword, they can just put that as a title to say, well, according to this case. But when you actually look at the case, it was never discussed on the merits.
I think the key challenge for you is how to make sure that will be selected in this at this stage, right?
Yes, and this is why I hired a law firm, Supreme Advocacy, and they've been in doing this for over 40 years. They've been in business for 40 years, and they're an expertise boutique law firm that specializes in Supreme Court cases. And I asked for them to give me a legal opinion beforehand, whether it was worth pursuing or not. And so I hired them to look at the case, look at the information, and because there's the gap in law, they believe it's a good case that might be selected. And so, but again, there's no guarantees. There's no guarantee whatsoever. The fact is, if I try to do this by myself, because I don't have the ins and outs and the right precise wording or whatnot, my chances drop from 10% to probably 1%. But because I have a case that can affect the whole nationwide in terms of precedents, they might be inclined to look at it just to give more precision, I guess, in the wording under the Canadian Human Rights under the Canadian Human Rights Act that would offer clarification, regardless of my case or not, right? So it would be a public good for the nation in order for them to offer this clarification. So maybe that can up my chances.
Yeah, that's right. It would clarify what could be used potentially by many other Canadians. So again, I thank you very much for sharing your story here. Do you have any questions or any further ideas which you wanted to share from your experience with the union, with the government, with lawyers, with courts? Anything?
Well, from the very beginning, I found that you know, when you feel all by yourself, you're all alone, and that's why you got to pick up and basically try to figure it out. It did not come as an easy task for me. You know, a lot of people have their own challenges, but for me, I had a newborn. I had a 2-year-old. I had like the 5 months old baby, and then we had just moved to a location where I needed to do some work and renovations, and I was not able to do that because I went into survival mode, and I had to cut out on expenses. And even then, to the point where, you know, some of the extra funds that I had allocated for renovations went to for living. So to this day, we don't even have a carpet in our living room, and our kitchen is still not fully renovated. Like it's just like bare wood essentially, right? But those are some of the sacrifice that I had to do in order to proceed with this, because for me, this is the importance of this is very significant, because this is the country that we'll leave for our kids and also for future generations. And if there's a wrong precedent, it's just going to compound and get worse over time. And if we don't address that right away, that wrong, and yeah, it can lead to bad stuff, right? Like to worse situation.
I will stop the recording here and have a few more questions for you.